Hello, everyone, and welcome to the Fearless Floyd Show. As always, I am your host, Fearless Floyd. Tonight, I am very proud to present Tanawah Downing, and I pray to God I'm pronouncing his first name correctly. And he's a gentleman. I ran across his information, and usually when I, see something, hear something, or somebody brings something to my attention, or a person, or whatever platform, I'll go investigate it. Went and checked him out, and I was like, hey, I've never heard of this guy. How come? Sounds like he's headed in the right direction, has a good mission statement. So I decided to invite him on the show like I always do, send him an invitation. He accepted, and here we are, Friday night, 6 o'clock, and we will be live with Tanawah Downing in just a minute. To let you guys know, I'm very, very, very busy. I am editing, multiple books, but I'm trying to get the trust book completed as much as possible. Still be able to prepare to do shows like this one. I may do one right after this one. I'm preparing another one because I have recently been sent and found, just by pure accident, information that connects all the pieces of the puzzle. What exactly happens in a criminal proceeding? Full monetized, all their evidence. I'm not making any documents up. I'm using their laws, their statutes, Dun & Bradstreet background business reports, stuff like that. So I'm putting all the dots together. Most of you don't know, as far as I know, that I've been able to investigate. I'm the only person in the world that's taken 3 government issued ID numbers on state and federal level, assigned in different decades. We can be that clear about it. And when they are put into the former, now defunct gmiutility.org website of the subsidiary or the parent company, Depository Trust Clearing Corporation, taking out all the hyphens and just hyphenating the last number on those 3 issued accounts, I came up with the same identical LEIs, legal entity identifiers, all over the world, same accounts. It was mind-blowing. When I got it to work on the second time, that blew my mind. And then when I connected the third one, you can't help but know beyond a shadow of a doubt, there's a there there. I've connected all the theirs, so we're going to lay it out. I'll do that in another video. As usual, when I have a brand new guest on here, I'll go peruse a little bit of their stuff, read a little bit about them. They fit somebody that I feel that should be, put out on Front Street so everybody can hear their voice. I'm going to do that. Very seldom do I have a conversation with them before we go on the show. I have not spoken to Mr. Downing. We've emailed back and forth, so I always like to keep it fresh. That way I'm dumb and ignorant just like you, and I'm going to have questions just like you will. I'm going to try to keep this under 2 hours, simply because once I do it under 2 hours, I can make AI shorts. If it goes beyond that, I lose that ability to do that. So if I need to have him back on, which I'm sure I would love to have him back on, I just now, and bless me, I'm busy. Just now cracked into a report to the governor from John Harris Thaler, that book, and it's the same size as Ann's trust book. So I'm going to get through that eventually, slowly, with everything else that I'm doing. I'm very busy. I've pretty much cut the world off so I can accomplish my goals of getting Ann's specialty trust book, the PDF, available April 1st, getting the printed copy completed and in my hand, ready to ship May 1st. Those are my goals, and that's what I'm working on as much as possible to get that accomplished. Let's see. If you didn't catch my Bolivar series, go check that out. If you don't know anything about Ann's new book, I'm actually co-writing that book with her. and it's balls in my court on that one. I am currently editing the final bonus chapter for a DNA trust. And I am 1, 2, 3, 4, 5, 10. I'm on section 10 of 15. And then I have a few more of the illustrations that I was telling you about from 23andMe to complete. I think 2 or 3 of those. So hopefully tomorrow I should be completely done with editing, be able to send everything back to Anne for her to restructure the entire book. And hopefully she will send me a PDF copy either over the weekend or next week that I can send out to all the wonderful people who have pre-ordered her PDF and softcover book, or both. So thank you for those people who have reached out and kind of given me a base on the number of books I need to order for this next round of printing. All the books will have an ISBN number in them now, so they will officially be registered books. There will not be just some self-published guy in his basement under his mom's house. My mom's passed away. Both my parents passed away. So, all right, I think I've given you enough drivel. I told Mr. Downing I'd have him on at 6:10. It is 6:09, and without further ado, let me tell you a little bit about him before I bring him on. Oh, yeah, it's over here. Whoops, wrong one. Well, where did it go? Here we go. Tanawah Downing, civil rights litigator and advocate. Mr. Tanawah Downing is a national civil rights advocate and litigator who is leading numerous initiatives intended to change the way in which justice is administered nationwide. He is an expert in constitutional law with numerous advanced degrees in criminal justice, investigations, and substantive law. With a focus on the principles in which America was founded upon, he works to ensure fairness, equality, and inclusivity in every endeavor that he undertakes. Mr. Downing spent many years at high levels of our nation's government, designing and deploying risk countermeasure programs that protected government from predetermined enemies, a concept that has been come to known as national security. It was then, after a series of tragic events, his perspective changed dramatically, and he came to understand that it is the people who need protection. Today, Mr. Downing fights exclusively for the freedom of every man, woman, and child, especially from the programs designed by our government that he helped implement in his prior ignorance. The first half of Mr. Downing's life was spent using all of his talents and knowledge to benefit himself, but in the blink of an eye and the swipe of a pen, it was all taken from him. I've been there, done that. Going forward, he decided that the second half of his life would be to use his talents and knowledge for the benefit of the people, so that together we might build something that will last. His efforts have now built what could potentially be the biggest civil rights case in American history, affecting every single United States citizen and changing the way in which law is enforced and justice is administered across the entire nation. Today, though, the only title that he carries is servant. And with that, let me bring Mr. Downing to the stage. How you doing, sir?
Doing great, brother. Thank you for having me.
Oh, you're more than welcome. It's a pleasure to have you on the show. And I'm eager to find out more about you and what your platform is, what your mission is, what your goals are, and how I can get my audience out here to possibly assist you and your endeavors where you need to go.
Man, that would be awesome. That'd be awesome. It's about time to make something happen. Yeah.
All right. I'm going to give you the floor. Tell us all about you.
Yeah. So my name is Tanawah Downing. I'm a national civil rights advocate litigator. 9 years ago, I was on the other side, guys. I fought for government, and I held a number of high-level positions in systems design, technology implementation, this concept and notion that we believe and call national security. But, during my ignorance, I've come to learn that national security is really code word for domestic terrorism, because you don't protect the government from the people, you protect the people from the government. I was on the wrong side, and it took me changing my perspective to come to understand this truth and this reality. And so I went through a very, very brutal divorce back in 2016, one that I didn't want, I didn't understand. At that point in time, I was the chief architect, managing consultant for some massive projects, one at LAX in particular. And I was getting ready to be bid as the chief architect for the Pentagon's video surveillance implementation program, which I was considered a shoe-in for that. I was the youngest chairman of the National Physical Security Council. I was a past chairman of the National Transportation Security Council. I have been appointed 4 times with the National Advanced Video Surveillance Working Group by Homeland Security. I had a lot of titles within government, and a lot of role in designing and deploying systems that mitigated human risk. And so it was during this time when I went through this divorce that I just came to realize that, you know what, these people need help. Because when I started suffering, I started realizing that there were a lot of people around me that were suffering that shouldn't be, that didn't really exist before. That homeless man, I thought he was homeless because he was lazy. I had no idea that he was homeless because there's 90,000 limitations placed upon him by a system that has been oppressing him and his family for 1,000 years. I didn't understand that prostitute was a drug addict because she was hurt and abused by the very people that that were there to protect her and take care of her. And so I didn't have the right perspective. I needed to change that perspective. And so sometimes in order to help others, you got to suffer alongside them. And that's just God's way of preparing us. And so that's why 2 people can be sitting side by side and yet have vastly differing perspectives of what is real and what's not, is because we don't have the right perspective. So for me, it was that period of time when I faced adversity in my life where some light started coming in that wasn't there before. And so I made the decision back then that I was going to step up and going to do what I had to do to fix the things that I had, at a minimum, that I had caused in my own ignorance. And we've gone way above and beyond that now. And I'm very honored to be able to serve people in the United States. I've done it every single day of my life since I entered into the workforce. And I will continue until the day God calls me home.
Awesome. So are you a licensed bar attorney?
Absolutely not. No. So there's a couple different tracks of law. One is adjective law. The other is substantive law. Substantive law deals with law enforcement, right? So I have the first half. An attorney goes through what's known as adjective law. They learn about the adjudication process. So they learn about ordinances, customs, statutes, judge-made rules. They learn about all the things that remove freedom, because that's what they're in the business of. They're in the business of making a person into a criminal, removing their freedom. I learned about nothing but the Constitution. That's all that I learned, right? And I studied substantive law, law enforcement. And so as a result, I'm in the business of restoring freedom. I'm not an attorney. I'm an advocate. I speak on behalf of others in a legal matter. They act on behalf of others in a legal matter. So I have a degree that a prosecutor really should have here in America, and that we don't see within the justice system today, because everybody within that courtroom all have a degree in adjective law. They all believe in judge-made rulings and that's the foundation of our law, as opposed to what the people created. And so I fight from the highest form of law. I don't come down off of it to argue down the weeds in case law, judge-made rulings, these other things that attorneys like to fight in, because that's where they tend to win.
Well, that's the bar machination system that they have to play in. And, I'm sure you've experienced this many, many times when you go in there with something that's not, within the norms of what they deal with in a court proceeding, they get all freaked out about it. And,
Right. And that's why, even our founders, because, we all know that the bar has its roots within English common law. I mean, there's no denying that. In fact, the heart of my argument has to do with the fact that judges don't make law, right? Judges make rulings, and rulings must be consistent with the positive law, because judges are tethered to positive law. That is the heart of my argument. That's the heart of my issue, is that we have a foundation known as the Constitution of the United States of America. That's supposed to be the foundation, and everything is to derive from it. But instead, we have these judge-made rulings that are called case law, erroneously called law at that, because there is a separation of powers that exists here in America, where judges have no legislative power whatsoever, and yet they create rulings and erroneously call it law, and then direct everyone to follow their law. Well, their law isn't law. it's a ruling, and a ruling. And so once again, like, that is the heart of it. But we know that the roots are embedded within the English common law system, because in England, judges do create law, right? Because in England, you have a monarchy, and that monarchy, he granted his authority to create law onto his agents, the judges. So in England, judges do create law, but not here in America. Here in America, we did not delegate the authority for any legislative power whatsoever. And that can be found within Clause 1, Article 1 of the United States Constitution, where it says all legislative power is vested in the Congress of the United States, consisting of a Senate and House of Representatives. There is no legislative power whatsoever in the executive branch or the judicial branch, which is what we're litigating right now. Is that, Chevron was a great example. In Chevron, it was executive branch. You don't get to do whatever you want to do. You have no legislative power. But now we're working on the second half, which is judicial branch. You have no legislative power either. Get rid of your stuff, and let's put the Constitution back as foundation, so that the people of the United States can have a predictable future, where we don't live in chaos and uncertainty, where judges determine what is or is not the law, where the people actually are the drivers once again. So in English common law, they do create the law there, but here in America, they do not. And so, when you consider, the roots of our system and the roots of the bar system, we can understand why, we are fighting a superior force. And, I look to the founders and what the founders did, and our founders, they fought asymmetrical warfare. They knew that they couldn't walk onto that battlefield with a superior force. They knew that they had to fight in other ways. That's why I don't walk into the courtroom. I'm not going to grant any of their bar, authority over me. I'm fighting in an asymmetrical manner in places that they don't expect. And so, and we're winning. We're winning quite handily right now. Yeah.
And what type of actions are these legal actions?
So when it comes to the issue, so let's just say that the Constitution of the United States is the overarching requirements that every state must follow. The states gave up their sovereignty to enter into a union and subject themselves to the supremacy of the United States Constitution. I think that any 11th grade civics class will teach you that, and you can easily understand that. But that means that states do not have the authority to be able to create their own alternative legislation, substitute it for the guarantees of the Constitution, and then go out and enforce it against people in the United States. Once again, Chevron, look at, if the executive branch saw ambiguity in the law, then they could write policy, go out and enforce that policy. And no, you cannot, because that would be amending the law by a branch of government that doesn't have the authority to do so. Right. But so the overarching requirements are the Constitution of the United States. So what we're doing is we want the Constitution back at its foundation. How do we get it there? Well, we got to remove everything that the executive branch put into place. We got that on June 28th with Chevron. The second one is now we need to remove everything that judges put into place. That's going to place the Constitution back at its foundation. But we're using what is called the indictment by a grand jury issue as the mechanism to actually get into the court. And let me explain what that is, okay?
Yeah, please do.
Clause 1 of Amendment 5 to the United States Constitution. I think that everyone would agree that's part of the Constitution. It was adopted and ratified by the people on December 15th, 1791 as part of the Bill of Rights. Therefore, it's part of the Constitution. No one is arguing that particular issue. Right. Well, Clause 1 of Amendment 5 says, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. So that's pretty clear. You better have an indictment by a grand jury before arresting someone, holding them over for a capital or an infamous crime. However, the state of Washington, Article 1, Section 26 of its inferior constitution says, no grand jury shall be drawn or summoned in any county. So now we have an inferior state constitution and a provision within it that functions directly to the contrary of the United States Constitution. Now we got a supremacy issue. Now we got to determine which law is going to be supreme. Now, when I started this litigation against the state of Washington 9 years ago, I thought that this was going to be localized. I had no idea how big this actually was, because it's not just the state of Washington that does not conduct a grand jury. There's actually 13 states that don't do it, including the state of Connecticut, state of Pennsylvania, state of Michigan, state of Oklahoma. These are states that are acting in direct, willful defiance of the procedures and processes established and codified in the Constitution of the United States of America. And that means that right now, today, there are more than 700,000 people currently in prison here in America on direct facial constitutional violations because the states did not follow the proper procedures and processes established, codified in the Constitution for the adjudication of crimes. This is a big deal, because if the arrest is unconstitutional because the state did not have the lawful authority to perform the arrest, because they didn't have the proper documentation in place to perform the arrest, Well, that means that everything deriving from that arrest must also be unconstitutional because it's all tainted by the illegality of the way it was obtained. If the arrest is unconstitutional because they didn't follow the proper rules to perform that arrest, that means that everything that comes after it must also be unconstitutional as well. There's a maximum law that states that any act unconstitutional at the beginning cannot become constitutional over time or by subsequent legislation. So if you act unlawfully, government, in the beginning, then what you're going to produce is going to be unlawful, because any unlawful act will result in an unlawful outcome. Right will always produce right, but wrong will always produce wrong. So we're using this indictment issue because 700,000 people imprisoned on direct facial constitutional violations of an enumerated constitutional right is a pretty big deal. But it's not just that now. It gets a little bit bigger because there's another 28 states that do not permit that permit their prosecuting attorneys to charge by information or indictment by their discretion. And unfortunately, discretion can never be used with regard to one's obligations, constitutional obligations, because the constitutional obligation is the law. Otherwise, you're using your discretion abusively to break the law, right? And nor can you permit a prosecuting attorney or a public official to be able to decide who gets a constitutional right and who does not. That would be obvious violation of the Fourth Amendment Equal Protection Clause. So now we have a much bigger issue that we need to get addressed. And once again, you know, a lot of people get me wrong. A lot of people think that I'm fighting for the prisoners. I am, because they've been wronged by the system. They've been abused by the system. I'm absolutely fighting for them, but I'm every bit as much fighting for those people that don't even know that they need to be fought for, because they don't understand that today you can be arrested for any arbitrary, capricious allegation by government. You can be put into a place where they will threaten you, intimidate you, steal everything from you, label you an aberrant individual, and you will have absolutely no recourse whatsoever, because the system is so efficient and effective that we actually believe that they're the good guys. And we need to understand that this institution that we call justice, it's not justice. This institution that we call honorable and good, it's not honorable and good. It's led by a bunch of criminals. So this issue of criminality that we're trying to address here in America, the way we're trying to do it, it will never be solved. You can't go out and arrest the people for the crimes they commit. You can't do it from the bottom up, because if our country is being led by criminals, and remember, a criminal is defined as simply one that transgresses the law. And I don't care what that law is, the Constitution or state statute. If you transgress the law, you are a criminal by the very definition. Therefore, if our country is being led by criminals, people are acting outside of their lawful authority, then that means our country is going to be led toward crime. And that means we're going to produce an environment of criminality, which will then produce a society of criminals. If we want to resolve the issue of criminality in America, we got to start at the top with our leaders. We got to make sure we got leaders that are going to lead our country in a lawful direction out of love, faith, obedience, respect for the people and the laws they establish, the very laws that grant them their authority and create their office. And until we do that, we're not heading in the right direction. So we're starting at the top. That's why my organization, its mantra is fighting crime from the top down. We need to go to the court that is responsible for this issue that we're in today, the United States Supreme Court. We need to hold them accountable for the criminal conduct that their despicable predecessors, that we have to call honorable, put into place. And we need to get them to own up to the illegal acts that their institution has committed for the last 243 years.
Have you investigated into filing into the Federal Court of Claims?
I am not yet. So so I have a very specific path, and okay, it may or may not work. But so what we're dealing with today is cognitive dissonance, right? In fact, I was just down at the United States District Court here in the state that I'm in. I don't want to say where I'm in, guys. I'm sorry, but there's certain things that we're doing right now that I don't want to expose where I'm at. But we were at the United States District Court today, meeting with some people, and we were talking about just that they are ignoring every bit of this, because Floyd, I have provided service to 42 state attorney generals, 42 state Supreme Courts notice of this that's happening. So let me just lay it out for you real quick, right? Yeah. So we have the issue of these states that created a law that's contrary to the Constitution. That's issue number one. That is known as sedition, because sedition is defined as the speaking or writing of words, such as law established, in order to cause disaffection to the Constitution, to procure its alteration in an other than lawful manner. So there's one way to change the Constitution. If you want to know what that is, you go to the special amending procedure of Article 5, and it'll tell you exactly how to change the Constitution. And it has nothing to do with the judicial branch creating edict and then directing. It has nothing to do with the states creating law and imposing its will upon the rest of the nation. In fact, Thomas Jefferson even said federalism is not a single state or small factions of states imposing the will upon the rest of the nation, but instead acts as an aggregate and an essential buffer between the central government and the citizens. So it's not about the states creating laws that are contrary to the Constitution and saying we're going to do it this way, because states, you gave up your sovereignty to subject yourself to the supremacy of the Constitution of the United States. You don't have the authority anymore to be able to do whatever you want because you gave up your sovereignty. The definition of a sovereign state is a state complete in itself, not subject to a higher government's laws. So the whole rhetoric about these states being sovereign is bullshit to begin with, right? But nonetheless, so here's the issue. Seditious law created by a state that is altering the Constitution of the United States in other than lawful manner. And then what they do is they direct their agents, the prosecuting attorneys, to go out. And those prosecuting attorneys, they have a duty and responsibility that's based upon their oath, that they must ensure the obligations of the Constitution are fulfilled, right? So that the rights of the people are granted, right? Because the purpose of the Constitution is to guarantee rights by limiting powers, right? By creating obligations of government that they must follow. And if the obligation says no person can be held to answer for capital or otherwise heinous crime unless on presentment or indictment of grand jury, that's an obligation of government to ensure you do not hold someone over unless there is an indictment by a grand jury. It's a prohibitory amendment of the Fifth Amendment, meaning that the Fifth Amendment's provisions are all prohibitory. They're all prohibitory provisions because what they do is they have an act of deprivation that is attached with a prohibitory element. So what the Fifth Amendment says there is it doesn't say you got the right to be free. It doesn't say government has the right to arrest you. It doesn't say you have the right to a grand jury. What it says is that you can be held to answer for a crime, but it comes with a prohibitory element being there must be an indictment by a grand jury. So absent the prohibitory element, then that means that the act of deprivation of government is unconstitutional and it gives rise to injunctive relief. All of the Fifth Amendment provisions are all that way. No property shall be taken for public use without just compensation. That doesn't say you can have your property. It doesn't say government can take your property. It doesn't say you get compensation. It says government can take your property, but it comes with a prohibitory element that you must be justly compensated. Absent the just compensation, the act of deprivation by government is unconstitutional, giving rise to injunctive relief. So you guys got to understand that Fifth Amendment, because the Fifth Amendment is really important because it's all prohibitory elements. Absent the prohibitory action of government, there is no act of deprivation that can be lawful or constitutional. Very simple. So the prosecuting attorney has a duty and responsibility to ensure that they follow the Constitution because they promise to do so. Failure to follow the Constitution, fulfill the obligations they have, they've already implicitly invited punishment in the form of perjury should they fail to fulfill such promise. That's the effect of the oath. So this is how it works, right? When the state created a law that's in conflict with the Constitution of the United States, when that prosecuting attorney decides to rely upon the inferior state statute to deprive a person of right guaranteed by the Constitution, they just committed a crime. It's called deprivation of rights under color of law, Title 18, subsection 242, which states any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any rights by the Constitution, commits that crime. This is a per se crime, meaning that we don't have to show that they intended to breach their obligation. Simply by virtue of the breach, all elements of crime have been met because their willfulness and their knowledge comes from the promise that they make. You make a promise, you take an oath, you must fulfill that oath. If you don't, then you've already implicitly invited punishment should you fail to fulfill that promise. That's what makes it per se. I don't have to prove any intent or willfulness because their intent or willfulness derives from the promise they make, okay? So that's pretty simple. So now we have a crime that's been committed per se. All I can do is show you had an obligation. You didn't do it, prosecutor. You brought the incorrect charging instrument. So now when they bring that incorrect charging instrument to a judicial officer of the state and they say to the judge, Judge, I'd like you to hold this person over for this offense. That judge also has a duty and responsibility to make sure the power he exercises is consistent with his authority. If he chooses to exercise the power based upon the prosecutor's abuse of power, who relied upon an inferior state statute to deprive a person of right guaranteed by the Constitution, that judge is also now depriving rights under color of law. He's a member of that, committing that base crime. But now he's established a conspiracy to deprive rights, Title 18, subsection 241, by and between himself and the prosecutor, which says when two or more persons conspire for the purpose of depriving any person of any rights to by the Constitution commits that crime. So when the judge then signs an order asking for this person to be held over and then hands it off to a law enforcement officer, Ask him to go out and perform the arrest. That law enforcement officer also has a duty responsibility to make sure the power he exercises is consistent with his authority. If he chooses to exercise his power based upon the judge's abuse of power, who relied upon the prosecutor's abuse of power, who relied upon the inferior state statute deprived person right guaranteed by the Constitution, that officer is also now deprived of rights under color of law. And he's also a member of the criminal conspiracy due to his negligence. And the moment that he goes out and performs that arrest without having the proper documentation in place, he's now committed the crime of kidnapping, as has everyone within the criminal conspiracy as well. And it is a federal kidnapping offense 1201 because they're holding the victim over for ransom in the form of bail. And now we have a very significant situation because anytime you have a deprivation of rights under color of law that occurs in conjunction with the kidnapping, the punishment as prescribed by law is death. So these are very, very serious offenses that are happening prolifically across this country in every single state because these judges and these prosecutors don't understand the limitations of their powers and their obligations to the Constitution of the United States. So what I'm doing is I'm taking an affidavit of actual victims within these states. I've identified them. Right now, I've almost got 500,000 criminal affidavits from across the country from actual victims in every single state that have been charged with or convicted of a crime by information, not by indictment. And remember, information is not an indictment. Information, according to law, subsection 18555, it can only be used as a charging instrument for misdemeanors. So when you use information to charge a person for a felony, you just committed that crime because the Constitution requires the indictment, not the information. It doesn't matter if the state told you you can do it. It doesn't matter if the judicial branch told you you can do it because the Constitution says you cannot. So right. I've now gone around this country. I started in May of last year, and between May and June 6th of last year, I served 32 state attorney generals with actual notices from victims within those states, served them on the assistant attorney generals over that period of time. Then after we got Chevron on June 28th, I turned around and I went out then and I started serving the state Supreme Courts. I went to the same 32 state Supreme Courts, served through their clerk of court, the same notice, exact same affidavit, very, very simple, very plain, of actual victims that have been, that were victims of crimes committed by their agents under their watch, and basically asking them to direct their agents to act in a lawful manner, but nonetheless identifying these crimes that are being committed. And so once I did those 32 and I returned back to Washington, D.C., then we've slowly gone out. We've served a number more. We're up to 42 states that are now enjoined serve notice. The highest executive officer being the law enforcement officer, as well as also the attorney general, as well as also the highest judicial officer of the state being the state Supreme Court. And remember, notice to principal is notice to agent, notice to agent is notice to principal, but notice to principal is notice to agent. So instead of going around and serving all these judges with notifications that they're committing crimes, we just went to their boss, said to their boss, hey, your agents are committing crimes. We want you to correct this behavior. Tell your agents to act in a lawful constitutional manner. And if you don't, then you are now implicated in it. You're now permitting it. You're sanctioning it. And as a result, you and every one of your agents are now involved in this criminal conspiracy to undermine the laws of the United States.
So is this a civil RICO that you're filing?
It will become. It will become. Okay. So where we're at right now is we didn't expect anything to happen from serving these attorney generals. We didn't, right? I mean, they're not just going to wake up and say, oh, yep, you're right. We're going to fix it. In fact, in the state of Rhode Island, I was just up in Rhode Island just the other day, and the attorney general of the state of Rhode Island, he was out campaigning just a couple months ago. And he said during a campaign speech at a high school, he said that he's aware that many of these statutes are unconstitutional, but he's going to continue to enforce them until told otherwise. Did you hear what I just said? He said he's aware that these are unconstitutional statutes and acts that they're committing, but they're going to continue to do it until he's told otherwise. He just admitted foreknowledge of an unconstitutional act, unconstitutional laws, and that he's permitting it, and not only permitting it, but sanctioning it and continuing in an unconstitutional manner. And yet he's still a sitting law enforcement executive officer for the state of Rhode Island. This is a despicable situation. So we didn't expect them to actually change. But what I am doing is there is one court that can fix this. And if they don't want to do it, when I show up there with this 500,000 criminal affidavits that we're now collecting across the country, because that's what we're doing now. We've served all the states. Now I'm simply collecting 500,000 criminal affidavits from actual victims across the country. Once I reach that number, I'm returning to the United States Supreme Court. We've already delivered the writ. We delivered it on September 29th of 2023. They've had it for plenty of time. They've had the opportunity to think about it, reflect on it, and they can either, one, they can let me litigate this. They can give me the opportunity to debate this finally, or two, we will start converting these criminal affidavits into criminal complaints, and we'll start trying judges for their criminal conduct. But it's going to start with those 9 justices there in Washington, D.C. I've told them numerous times, I don't want to go that way. I think that's going to be really messy, but you guys are going to have to decide what you want to do, because either one, you step up, you decide to return to established rule of law, and we work together to fix this problem consistent with what the law demands, or two, you continue to lie and pretend like nothing's happening. You continue to ignore this and not hear it, in which case I'm going to make sure that the entire country knows that the traitors, the real traitors of this country, are located in Washington, D.C., and I guarantee you they're going to be the first 9 heading to the gallows.
I think the majority of the people are aware of that already. I have my own experiences I could, sit here and go on and on about, but the show's about you and your efforts. So what circuit are you in right now?
We brought it to the 9th Circuit, but we're sitting on a jurisdictional error. So we're on a jurisdictional error. There was a remand order that was submitted to the Supreme Court, but we have a jurisdictional error. And because it's a jurisdictional error under Civil Rule 60b-4, we have no time limits for submission. So I can wait as long as I want, because a jurisdictional error is when a court exceeds the power or authority statutorily conferred upon it by the Constitution. Jurisdiction is created by the Constitution. This is the jurisdictional error. So the case that I brought was versus State of Washington. Now, state can't be named a party, because if a state is named a party, according to Article 3, read it. Article 3, Section 2 says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. Now, this is something that's been forgotten. It's been forgotten for almost 160 years. I believe that the last time original jurisdiction was invoked at the United States Supreme Court was back around 1890, because we've forgotten about it. But in the Constitution, under Article 3, it identifies 2 different instances in which the United States Supreme Court has original jurisdiction, not appellate, original. And that is 1, anytime that a foreign dignitary is named a party, or 2, anytime that a state is named a party. Okay? And so that's why it says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. And then it goes on to say, in all other cases of equity and law, the court shall have appellate jurisdiction. So we're all very familiar with the United States Supreme Court's appellate jurisdiction, because we invoke that every single day, right? We believe that's a court of last resort. We don't believe or understand that it's a court of first resort if a state is a party in cause. Now, let me tell you, let me tell you why original jurisdiction says what it says, okay?
That's mind-blowing.
If you want to understand the original intent, and remember, we have an originalist textualist court on us, right? Like this is the time for this to come forward, because the majority of the people on the court supposedly believe in the original intent of the Constitution. But if you want to know why the founders, the framers of the Constitution wrote the things that they wrote in it, we would typically go to the Federalist Papers, right? In fact, right. Justice Gorsuch says that James Madison is the person that provides all authority to the Constitution. He's the father of the Constitution. So if we want to know why Article 3, Section 2 says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction, let's see what James Madison had to say about it. Because he wrote in the Federalist, Circular number 10, what he said is, he said, no man is allowed to be judged in his own cause, because his interest would no doubt bias his judgment, and not improbably corrupt his integrity. With equal, nay, with greater reason, a body of men are unfit to be both judge and party at the same time. So what James Madison was pointing at, this is actually the earliest known reference to the modern day concept of conflict of interest. James Madison was trying to formulate the idea of conflict of interest within this, when he says that their interest will no doubt bias their judgment. He's referring to the conflict of interest that we talk about today. This is the earliest known reference to the modern day concept of conflict of interest, written by James Madison, Federalist Number 10. And again, what he said is a body of men are unfit to be both judge and party at the same time. You cannot be both accuser and judge in the same cause because of the obvious conflict of interest that exists, right? Therefore, any judicial officer has a mandatory, non-waivable, self-executing duty to recuse himself if he's an officer of either party. And thus, these are judicial officers of the state who it just so happens to be a member of the party. Now, that's just what James Madison had to say. You know, maybe I'm interpreting that wrong. So let's see what Alexander Hamilton had to say, because he also wrote the Federalist Papers, right?
Yeah, he did.
Alexander Hamilton wrote the Federalist Number 80. And what Alexander Hamilton said is he said the federal judicial authority of the Union must extend to all cases between a state and the citizens thereof. That's pretty clear. You got a dispute between a state and citizens thereof. The federal judicial authority must extend. But you know what? He also wrote something else in the Federalist Number 80. And what he said there is he said state tribunals cannot be presumed to be impartial when they speak for themselves. No man ought certainly be judged in his own cause or in any cause with which he has the least bit bias or interest. State tribunals cannot be presumed to be impartial when they speak for themselves, right? So now we got Alexander Hamilton talking about the fact that if the state tribunal brings an action against you, that state tribunal cannot speak for itself. That's two of the authors. The third author of the Federalist Papers was a man named John Jay, and he just so happens to be the first Supreme Court Chief Justice that we had. He didn't write anything in the Federalist Papers that we can find, but he sure the hell did in the case called Martin versus Hunter's lessee. Because what he said in the case Martin versus Hunter's lessee is he stated that state prejudices, state biases, and state interests might from time to time obstruct the administration of justice by state judges. Therefore, it is the case and not the court that grants original jurisdiction to the Supreme Court. He said the Constitution is presumed that state attachments, state prejudices, state biases, and state interests might from time to time obstruct the administration of justice. Therefore, it is the case and not the court that grants jurisdiction to the Supreme Court. Because in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. If a state brings an accusation against you, and I don't care who that is, whether it's CPS, whether it's an officer, whether it's a judge, whether it's a prosecutor, if the state brings an accusation against you through any one of its agents, that state may not be judged in that case. And as a result, that state must recuse itself, and failure to do so means that that state is acting without jurisdiction in direct conflict with the Constitution of the United States. And now we have a very, very, very big problem, because all of these cases across this country are state of whoever versus you. And now we have an unconstitutional jurisdictional error that has occurred.
Theory.
Yes.
State files a suit against me for DWI. State of Texas versus Floyd Pleasant Harvin IV. So if I want to countersue, I would file it in the United States Supreme Court, not back in the court of original jurisdiction.
That court did not have jurisdiction.
So you're going to a superior court to counter.
So if you want to follow the law, if you want to obey the law, which we have to, because remember, ignorance of the law is no justification for having broken it.
Right.
So if you're told to file your case within the United States District Court, for instance, and you decide to do that, unfortunately, you just broke the law. Even if someone told you to break the law, you chose to do it because you didn't file in the proper court. The Constitution says if the state is a party, it must go to the United States Supreme Court. And we got to learn how to follow the law. It doesn't matter what Congress tells us to do. It doesn't matter what a judge tells us to do. It doesn't matter what an attorney tells us to do. We have an obligation to follow the law. And if the law says that that's the court that has original jurisdiction, never been changed, never been altered, it is sitting right here as plain as can see, we got to follow the law. And I'm going to tell you right now, that's the reason why you all are losing your cases, is because if you choose to break the law, don't be surprised if you don't prevail in that law. We have got to decide to follow the one thing that governs over us. The one thing that we're bound to follow, let's follow it. And so that's why I say, and I've said this for a year and a half, couple of years now, we have got to stop following criminals because that's leading us toward criminality. We got to make a decision that from now on, I'm not going to follow that fucking criminal. I'm not going to follow him the direction, because if he tells me to go to the lowest court, I'm going to say, no, I'm going to follow the law. I'm going to go to the highest court. If he tells me to argue case law, I'm going to say, oh, no. I'm going to argue constitutional law. If you tell me to file an appeal, I'm going to say, oh, no, I'm going to file a writ of habeas corpus. I'm going to do the opposite from now on because I don't like the direction you're sending me, because we're losing going that way. We're all becoming criminals going that way because we're choosing to follow a bunch of criminals. So what I'm doing more than anything else is I'm drawing a line of sand because I deal with law enforcement. I deal with the first half. I find criminals and I hold criminals accountable for the crimes. And I'm giving them an opportunity by drawing a line of sand. I'm saying to them, this is what the law states. You guys are clearly operating outside of it. And you got a choice now. You can either return to established rule of law, work with me, or you're going to be known as a criminal. Because I can't prevent you, public official, from exercising your power. But what I sure the hell can do is I can show you that should you choose to exercise your power without lawful authority, that's going to make you a traitor. And we're going to make sure that the whole country knows of your treason. Because once again, our country is being led by criminals, and that's not the direction we want to go anymore. So to answer your question, the court that filed against you had no authority whatsoever to take action in that case. And so what it's produced now is void. Civil Rule 60B4, okay? Mm-hmm. In order for a court to render a legally binding decision, it must have two things. It must have subject matter jurisdiction, and it must have personal jurisdiction. Subject matter jurisdiction is the right to oversee the type of case that's brought before it. So, for instance, in the case of a death, you wouldn't bring that to a small claims court because they wouldn't have subject matter jurisdiction to oversee the disposition of deceased assets. You would bring that to a probate court. That would be the court that would have subject matter jurisdiction. Now, the second thing they must have is they must have personal jurisdiction, which is the right to oversee the parties involved in the dispute. Right. So when the Constitution identifies two instances in which the United States Supreme Court has original jurisdiction, then that means that they have personal jurisdiction. And that's anytime that a foreign dignitary is named a party, or two, anytime a state is named a party. If a state is named a party, the only court in the country that has jurisdiction to oversee it, according to the Constitution, is the United States Supreme Court. Now, remember, because this is a constitutional obligation enumerated within Article 3 as an obligation, that cannot be delegated and it cannot be discretionary. This has long been litigated, because if they can delegate it, then that would mean that the United States Supreme Court is amending the Constitution and removing their obligation assigned to someone else. That would be an alteration of the Constitution, amendment of the Constitution in an other than lawful manner. It must be changed by the people, and until it is, you may not delegate it to another court. Now, it cannot be discretion either, because if it were, then that would mean that they could use their discretion abusively to break the law. And you cannot use discretion with regard to one's obligations. Obligations must be performed. That's long been litigated. So when you do go into the Supreme Court of the United States and you invoke Article 3, your right to an original jurisdiction, you're not asking them to do anything. You're not saying, court, please review a lower court decision. No, what you're doing is you're going in there and you're saying, you have an obligation to do this, constitutionally codified. You can either fulfill your obligation, or you can tell 330 million people that what they believe in isn't real and that you're not going to obey it anymore. And good luck getting home, Supreme Court justices, because that's not going to go very well for you. So, this has not been litigated. Now, this was litigated in 1793, a case called Chisholm versus Georgia. It just so happens to have been the very first case that the United States Supreme Court ever heard was on this particular issue. We're about to litigate it again. And what's even more amazing is that Chisholm brought an argument that was basically a dispute between A and B is most certainly a dispute between B and A. And what he was doing was he was comparing the fact that if you have a dispute between A and B, and you simply transpose those to B and A, they're the same parties. It's the same thing. You don't change what they are based upon their position. That was Chisholm's argument. My argument is, if 1 + 2 = 3 is unconstitutional, clearly 2 + 1 = 3 is also unconstitutional. Simply rearranging the order of the parties does not magically change the representation of the parties. So if it's unconstitutional for it to be Tanawah Downing versus the state of Washington, because the state is named a party, and that's what the Supreme Court they've already determined that. That's where the jurisdictional error exists, is that I had state of Washington as the opposing party. They said, oh, no, state can't be opposing party because the district court doesn't have jurisdiction. The only court that does have jurisdiction is the Supreme Court. Therefore, the jurisdictional error was created. But I pointed out in the remand order, I pointed out the fact that, yeah, but if you want to simply reverse and remand and send me back to district court and not hear this, then by saying that it is unconstitutional to have the state of Washington be the respondent, then what about in the criminal matter with state of Washington versus Tanawah Downing, right? You can't say that it is unconstitutional for the state of Washington to be the respondent, but not the petitioner. Therefore, go ahead and litigate this. Let me hear this case. Let me get the people the rights that they're guaranteed, because that's why I did all of this. That's why I chose to come and do this, to create these errors and to do this, is because the people needed these rights. This is what they're guaranteed. But going back to your question there, the state of Texas had no authority to be the petitioner or the respondent, because the state is named a party. And if the state's named a party, doesn't matter where they're at, if they're named a party, the only court in the country that has personal jurisdiction to oversee that is the United States Supreme Court. And according to Civil Rule 60B4, it says that a judgment is either valid or void. It's valid in all instances except for when the court rendering decision lacks either subject matter jurisdiction or personal jurisdiction. If it lacks either subject matter jurisdiction or personal jurisdiction, what it produces is a void judgment, and a void judgment is always and forever void. It can never become valid because the court can never obtain jurisdiction when it lacks jurisdiction. And this was just litigated at the Supreme Court just last year, beginning of last year, when they said that the difference between a claims processing rule and a jurisdictional rule is that a jurisdictional rule can never be waived, can never be forfeited, because the court can never obtain jurisdiction when it lacks jurisdiction. So the difference between an appeal and a jurisdictional rule is that the court's first duty is to the jurisdiction. Absent jurisdiction, that court has no authority to do anything at all. Therefore, what it produces is automatically void. It can always be challenged, can never become valid. And as a result, whatever you're talking about right there is void on its face. And so you need to go to the court that would be able to address the jurisdictional error that exists that would automatically void the judgment. But you don't come in under an appeal because there's nothing to appeal. If it's void, it's done. So now you're going into saying, hey, I have this action against the case, against the state, where they denied me liberty. They've stolen property from me. They've deprived me of rights without any lawful authority whatsoever. And I want you to restore everything that they've taken away from me. You do that through a writ of habeas corpus, not an appeal.
As you spoke about that, I'm reliving, because I don't know how much investigating you did into me. I'm published all the way to the Supreme Court, and been through the mud. And I'm thinking about all the Rule 12b-6 dismissals that, just one after another after another. And now it all makes sense because we were suing the state of Texas.
Yeah.
In the U.S. District Court, Southern District of Texas, Houston Division, various stated claim for which relief may be granted. Wrong court.
Wrong court.
They didn't tell us that.
And they're not going to tell you that.
Yeah. Wow.
So let me tell you the deceptive nature of this system right now, because they've known about this for a long time. A long time.
Oh, yeah. Of course they have. Yeah.
Because in 1925, the Judicial Reform Act of the United States Congress came out. The Judicial Reform Act of 1925. And they led the people astray. And they basically legislatively foreclosed upon original jurisdiction at that point in time. Let me tell you what they did. They did two key things in that legislation, right? Both indicative of the Congress's knowledge of this situation. First off, what they said is that all of the Supreme Courts, the federal Supreme Court and the state Supreme Courts, are all now courts of discretion, right? Meaning they can pick and choose which cases they want to hear or not hear. Discretion came in 1925. Prior to that, they were not a court of discretion. But in 1925, they became a court of discretion.
What was the instigation for that? Was it an act, a treaty, a Congress?
So what happened was that in 1833, the United States Supreme Court came out under the Marshall Court, and they said in a case called Barron versus Baltimore, they said that the Bill of Rights, which is the first 10 amendments to the Constitution, that those are not a restriction against the state government, but rather a restriction against the federal government. So all of a sudden, no one
Wow.
was protected by any of the Bill of Rights. Now they did that. They made that ruling for one specific purpose. And that purpose was they were paving the way for the First National Bank to be put into place. It was 1833 when the First National Bank was established. Now, the court knew, the federal government knew that they were going to sue, that states were going to sue if they established that national bank, because they knew that the greatest way to enslave a society is through debt. So they knew that states were going to sue. Now, in order to sue in federal court, in order to have standing, you must, one, be directly impacted by the person, or be directly impacted by law. And two, you must represent people or be a person, right? So obviously, the states could sue the federal court if they established it. So they had to make it so the Constitution didn't apply to states. That's what they were doing there, right? So Barron versus Baltimore, they say, oh, guess what? Constitution doesn't apply to your states. And as a result, now you don't have standing. First National Bank is established 6 months later. States can't sue because the Constitution doesn't apply to them. And now they paved the way for that First National Bank. That was why they did it. But the problem is that they were partially correct, and that the Bill of Rights doesn't apply to states, because the Bill of Rights applies to the people, including those people that reside within the state. It was a deceptive ruling that they put in place simply to establish that national bank, make it so that states couldn't sue. But nonetheless, that's the reason why today you don't get an indictment by a grand jury, is because no one has ever corrected Barron versus Baltimore. Now, what happened was that Barron versus Baltimore, 1833, Supreme Court comes out and says, nope, the Bill of Rights are not a restriction against the states. It's only a restriction against the federal government. And as of that moment, you didn't have any of the rights contained within the Bill of Rights except for within the 10 square miles of Washington, D.C., right? The only place federal. So that's why you can go to Washington, D.C., you can break law, you can be a criminal, you can do all these criminal things, and yet you're protected by law because Bill of Rights applies to you. It doesn't apply to a state. It's never been corrected. Now, 1925 comes along, and remember, 1925 was the Judicial Reform Act. February 1925, there was a case called Gitlow versus New York. Gitlow versus New York came to the United States Supreme Court. And Gitlow was challenging his right to freedom of speech. And the court came out in 1925, February 1925, and they said, yes, the freedom of speech is protected against interference because it's codified in the Constitution's text. And now the freedom of speech is protected because it's in the Constitution's text. Well, the Congress came out and said, what did you just say, Supreme Court? What are you talking? It's always been protected, right? And they said, no. It's not protected because it's Barron versus Baltimore. Congress said, oh, shit. That's a pretty big deal. That's a pretty big deal. Here's what we're going to do. We're going to make it so you can pick and choose which cases you want to hear or not hear, because we don't want you to have to address this issue. Because what started there was what is known as the incorporation doctrine. And you guys, if you've ever heard of the incorporation doctrine, this is what it means. 1925 started the incorporation doctrine. They started incorporating each of the Bill of Rights one at a time as cases came forward, such as 1966 Miranda versus Arizona, the right to not self-incriminate, right? So that came forward and they said, oh, yeah, that's protected. It's incorporated, right? Or 1968, Duncan versus Louisiana, which is the right to a jury trial, or Wainwright versus Gideon. I mean, all of these were each individual cases that one at a time started incorporating. Now, you would think that in 1925, when they say, yeah, freedom of speech is protected against interference because it's in the Constitution, you would think that they would all be incorporated as of that moment because they're all in there, but not true. They started slowly doing it. Guys, the last right that was incorporated was in 2019. It was a case called Timbs versus Indiana, TIMBS versus Indiana. And it was the right to the Eighth Amendment's excessive fines clause. That was the last one to be incorporated. And what they said within that ruling, guys, listen to what I'm saying here, okay? They said that the privileges and immunities of United States citizens are at a minimum those enumerated within the Bill of Rights, given their legal effect against interference by the states because of their codification in the Constitution's text. In other words, if it is written in the Constitution of the United States, it is within the Bill of Rights, it is at a minimum what you are guaranteed as a United States citizen, no matter where you choose to reside within the jurisdiction of the United States. All right. So that being said, everybody, the incorporation doctrine has incorporated now every single right except for one. There's one left to be incorporated. One left to go, and that's called the grand jury clause of the Fifth Amendment. And this one was the hardest one of all to get, because this is the one that's going to set the people free. This is the one that they didn't want to ever have to admit and never want to have to incorporate, because this is the one that's going to say, government, we got to go back to 1833. We got to go back to when you guys created a ruling that fundamentally altered the Constitution of the United States, when you decided that you were not going to give the people the very rights that are guaranteed to them by their birthrights, because you wanted to create a national bank. We got to go back to 1833. We got to say, rip that shit out from the foundation, because that's not the foundation, the Constitution's foundation. And when we do, that means that every single criminal case across the entire country, ever since 1833, is presented to Barron versus Baltimore. There isn't a single case in this country that can be proceeded under a criminal matter until the highest court in the land corrects the unconstitutional and illegal and seditious ruling that court put into place in 1833, when it directed all the courts in the country that you don't have to give the people the rights that they're guaranteed by their birthright, written and enumerated for all to see within the Constitution of the United States. Give us those rights. Give them to us finally. And when we go back to Barron versus Baltimore and we remove it because it was seditious, created by a bunch of slave owners, then we get to see the dust settle where it may. And when you remove the foundation, right, when you remove the ruling that was put into place that permitted all these states to not follow the Constitution, when they decided to enact their own alternative legislation that says we're not going to do a grand jury, they did it because the Supreme Court of the United States in 1833 said you don't have to do it. And if it's deemed that the Supreme Court's ruling is unconstitutional because it fundamentally altered the Constitution and deprived people in the United States the very rights they're guaranteed, then that means that all the states' inferior statutes that they created, relying upon it, are also unconstitutional, which means that every single contract that was created by every single state that relied upon those inferior state statutes that deprived the person right guaranteed by, they're all void, because they all derive from the criminal acts committed by the highest court in this land in 1833 by a bunch of slave owners. When I say slave owners, I mean slave owners, because of the first 28 Supreme Court justices that served on that court, 22 of them owned their own slaves. And then you wonder why we have a slavery institution that's permeated itself into every single jurisdiction across America, why every single state has got for-profit businesses that employ people that are aberrant and criminals into a forced involuntary servitude that we would call a prison or a sweatshop in China, but a prison here in America. This is not the way you're going to treat our people any longer. We're going to get them out of these institutions. We're going to get them back home to their families, get them the love and support they need, so we can actually get out of this fucking slavery institution once and for all, because it's disgusting what that court has done to the people of the United States when they've lied to them and robbed from them for 243 years so that they could profit off their illegal acts.
So basically, that's the gist of your movement right now, is on that Fifth Amendment issue, which you consider the final nail in the coffin.
The Fifth Amendment is the low-hanging fruit. The argument is a state cannot be both accuser and judge at the same time. You know, the issue is can a state be a judge in a case in which the state itself is a party? And the answer is absolutely not. And that affects every CPS case. That affects every single guardianship case. That affects most probate cases. We are using prisoners and indictments by a grand jury to get in and to argue for every single person involved in this unjust criminal system, this unjust justice system across the country. We're going to fight for every single one of them, because until that highest court in the land steps up and starts to act honorable, we are no longer going to be standing up in their presence or calling them honorable or give it, because just nothing but a bunch of criminals.
I'm going to read you one sentence. This is out of the book, which was published in the 1920s, and they republished it by Forgotten Books. Not an endorsement, folks. This one sentence, and I caught it digging through the table of contents. Warehouse receipts required to be issued by warehouses independent of the borrower, which means that the warehouse receipt issuer, which is the state district judge here in Texas, and he's borrowing the money for the state, right? Because the case is bonded.
Yeah.
There you go. One sentence. And that's what I'm putting together. I don't know how much of the front end of the video or the show that you caught when I was addressing all that, but I'm putting this together. Um,
Yeah,
yeah, these,
I had a conversation with some people earlier about the banking nature of the system, and the bonds as well. I mean, the way that Roman common law used to work
yeah,
is that if you had a dispute, you would bring in a bond, right? You bring in a bond to the court, and then the respondent would bring in a bond to the court, and then you'd have your dispute, and whoever lost would then give their bond up to the Roman Catholic Church. That's the way it worked. And the same thing happens today because these are all bonded jobs, right? They're every single thing that we do in that courtroom is commercial. A court of record, right, which is that court, the highest court, a court of record can only do a maximum of $25,000. Every single crime has a monetary amount attached to it.
right.
So murder, for instance, would be $25,000 because that would be the maximum amount. So they had that amount assigned to it. But then, like robbery might be 5,000 and assault might be 1,000, whatever. There's a monetary amount that's attached to every single criminal act. And so what happens then is when you walk in that courtroom, when you don't understand the bond element, right? You don't have a bond that's sitting there that they can attach to, then you have to sell yourself into slavery to settle that debt because it's all about money. That's why this is a debt-based system. That's why the judge is a banker. That's why this is a marketplace. That's why that's why they have bonds. That's why the whole system itself. If you choose to violate the law, you incur a debt that is owed to society, to which you are charged and called to account, so you can pay the debt. That is a debt-based accounting system. So it's all monetary based on account. So, a great example is if you had a bond for $25,000 and you walked into that courtroom on a criminal matter and you lost that criminal matter, you could point to that bond and say, Judge, take it from the bond. I'm not going anywhere. They can't send you to prison because it's a monetary based system. The only reason why you go to prison is because you can't pay that debt because you didn't understand that it's a debt based system. Walk into that courtroom with your debt already assigned and available, and guess what? If you lose that debate, then they can take from the debt, and they can't send the person off to prison. You don't have to sell yourself into slavery because you've already figured out that it's all monetary based. That's all it is. It's based upon money. If you can pay your debt to society, you don't go to prison, and that's the way that the system works. But most people don't understand that these are nothing more than bankers. I mean, and we know that. Like, this is well known. The courtroom was always known as the marketplace. It's always a rhetoric based. And so, anyway, that's what my forensics degree has long since taught me. Forensics is nothing more than a degree in rhetoric. I develop an argument, and I rhetorically present that argument in such a way that it doesn't require a response. What we've done here, the case that we built is so complete that 42 states can be served with notices that every single one of their agents are committing crimes, and they don't even have a response to it. They don't have a rebuttal to it.
No, they can't.
Nothing to rebut.
Yeah. Throw themselves under the bus. Suicide note.
I mean, why would you engage someone in a debate that you're going to lose? They know they're going to lose. And that's why they're so scared of what I got going on. That's why, that's why I'm being very careful, as careful as I can be about, disclosure locations and things of that sort, because, there have already been some attempts on my life, but God's got this under control, and I'm going to make it to that courtroom. I'm going to deliver this because somewhere someone's protecting me. And I don't know if it's on the executive branch side or the judicial branch side, but I do have some protection out there because there is a do not detain on me. And the last thing they want is me in a courtroom, and they know that. So, so I do my work. I'm getting it done, but it's not easy to do it.
So, are you assisting other people doing their own pro se, pro per litigation,
No.
or just focusing on your own?
No. So what I'm trying to, you see, one thing that I like to explain here, a lot of people look at what I'm doing and they're like, oh, it'll never happen. It's too big. It'll never happen. And I'm like, you know what? Size is not indicative of losing. Size is indicative of winning. Because let me give you an illustration here. There's 2.9 million people currently incarcerated here in America, right? Currently incarcerated, 2.9 million. Those 2.9 million people, Those 2.9 million people, they all had rights, and they were people. They all had rights. Those rights were abridged. They are unconstitutionally being held because the courts that put them there didn't have authority to be able to oversee that dispute. So there's no denying that. They're all illegally and unconstitutionally being held today on something that isn't even valid. The only things holding them there are a bunch of goons with guns, right? And their fear of actually walking out of there. So I've got 2.9 million people standing behind me right now that were all people that had rights. Standing in front of me is the Supreme Court of the United States, who behind them are 40,000 criminals, because there's 40,000 judges across the country. Every single one of them is criminal right now, who's acting criminally against the 2.9 million people standing behind me. So to show the illustration here, 2.9 million people who could all talk about the same issue, jurisdictional issue. You see, one of the reasons why I don't have the attention that I need is because all these people over here are talking about their own pro se cases, their own issue. They want to talk about the rules of evidentiary procedures. They want to talk about the biasness of the judge or the lies from the prosecutor. They want to talk about all these things. I'm saying, guys, stop talking about that. Let's talk about the very first step. Did the court have authority to call you into that courtroom? Did the court have the authority to arrest you? Because they didn't have, if we talk about that issue right there, every single one of you can talk about the same thing.
Define that for people, the authority to arrest you, what that looks like.
An indictment by grand jury, issued by grand jury, based upon evidence that was presented, and your right to be able to confront the hearsay accusations against you. You must have an indictment by a grand jury consistent with the Constitution of the United States to perform an arrest. And if you do not, then what you've done is unconstitutional. And remember, it says no person shall be held to answer. So even if you arrest someone and then 4 months later you get an indictment, that is still unconstitutional because you held that person to answer for an infamous crime without an indictment by a grand jury. It's very, very clear and simple.
Putting the cart before the horse.
Right.
What you're saying.
Right. And that's assuming that you did get one. But I'm telling you right now, over 700,000 people in prison never even got one. Never even got one. Right? There's a lot of people that got them afterwards, but over 700,000 people right now never even received one.
Yeah, there's some that plea bargained out before they even got indicted.
Exactly. Well, but a lot of them don't indict. Like the state of Washington has never, in the history of the state of Washington, ever convened a grand jury. State of Connecticut hasn't convened a grand jury since 1984. When they yes, they removed the grand jury from their constitution in 1984. They have not ran a single grand jury since 1984. And yet the Constitution of the United States requires it.
And the prosecutor's doing it like a municipal traffic ticket prosecutor, where they have all the discretion.
All that they're doing is saying, I have the power to say you're a criminal. I can sign this information on behalf of my client, and you're now the opposing party, and I'm going to lock you up. I'm going to accuse you of anything I want. I'm going to bring whatever hearsay accusations I want against you so I can force you into doing whatever it is I say you did with whatever punishment I demand. That's the one-sided nature of this system. There is no neutral, unbiased decision maker. Remember, the purpose of the grand jury is to protect the accused from hasty or malicious charges by an overzealous prosecutor. So now you have an overzealous prosecutor who denies the accused the right to be present to confront the hearsay accusations against them in a proceeding that's there to protect them from the prosecutor. Were you in your grand jury when they indicted you?
No.
Were you ever given your indictment? A copy
yes.
of it signed by the Was it signed by the grand jury foreman, or was it signed by the jury, by the prosecutor?
I believe mine, I had two. I believe it was signed by the assistant grand jury foreman.
Signed by the prosecutor.
Oh, yeah. No doubt.
So they're all signed by the prosecutor? But let me ask you another question then. Were you given your transcripts from that grand jury?
No.
How can you prepare a robust legal argument against accusations when you don't know what those accusations are?
Yeah, you can't. And I'm a perfect example. And my case is very unique because my DWI offense date was July 10th, 2001. If you remember back in the late 1990s and early 2000s, Mothers Against Drunk Driving was in full force, full throttle, created in Dallas, Fort Worth. I'm a poster child for being a victim of Mothers Against Drunk Driving. I got a 60-year sentence for my third DWI, and I'm not saying, hey, I was a saint or choir boy by any stretch of the imagination. I was labeled a danger to the citizens of Harris County, Texas by my sentencing judge. And in hindsight, I was, an idiot, a moron who did a bunch of stupid stuff. But it doesn't change the fact of the law in effect at the time. Because of Mothers Against Drunk Driving, they wanted to penalize more habitual repeat DWI offenders. So they went in there and started monkeying with the elements of the offense so they could catch more repeat offenders. And in doing so, in September 1st, 2001, they changed it, which had been since it had been further than that. It was originally a transportation code. 1994, they revamped it, put it in the penal code. It stayed that way until September 1st, 2001. Then they added some new elements that had to be alleged and proven. Then in 2003, they changed it up again. Then in 2005, they's like, that's just too much for us to go find and prove, because they wanted you to, part of these stipulations were the date you finished community supervision, the date you got out of jail, the date you got off parole, the date you got out of prison. Well, these are dates that the prosecutor would have to go find. They'd have to go research and go through not only their records, but go through parole records or probation department records to look for these final orders, whatever. And they weren't doing it. What they were using is the boilerplate template out of, I don't have the book here, but here in Texas, we have a Texas County and District Attorneys Association. And they publish their own set of books, just like the O'Connor set and West and all that. And in that, they put boilerplate templates for the indictment. So this is what a felony DWI indictment should read. And basically all they're doing is just putting in that you've twice been previously convicted of a DWI, and now your primary is enhanced to a felony. Well, for my particular case, I had to have an intervening DWI commission within 10 years of my primary. So how the court looked at it is the primary in 2001, you go back 10 years to 1991. If you committed a DWI in that time, they could go back and get your 2 prior convictions and use them as a felony enhancement to get you to a 3rd degree felony DWI. Okay. After that, they changed it to all the 4 things that I described earlier, community supervision. Well, I've read dozens of felony DWI indictments in Texas. Not one alleges all the elements that are required per the statute in effect at the time that they were indicted. So that's a huge issue. And, it opens the door for every felony DWI ever in the state of Texas.
Yeah. Yeah. Well, I mean, nonetheless, I mean, how are you going to, you see, the way that debt normally works, and if this is a debt-based system, which it is, like the way that debt normally works is if I want to buy something from Sears and I open up a $1,000 credit line, when I pay that $1,000 back plus interest and fees, my debt's released and forgiven. That's the way that all debt works in all humanity, except for this debt, right? This debt, you pay for it again when you go and get a job. You pay for it again when you go to jail. You pay for it again when you get fines and fees. You pay for it again when you go to get a license or go to church. And then God forbid you ever get more debt, because you're going to pay for that debt in addition because of the point system on debt that you already paid for.
Right.
Why is debt function differently than every other debt known to mankind, right? Once debt is paid for, you're released. But not with this debt. You're never released with this debt. That's the fraudulent nature of this debt. And that's why, you know, if I could, let me explain where the fraud comes from, because there's two main places where it comes from.
I'm gonna
So,
give you the floor.
okay. Actually, let me grab a water here real quick here. So this is the I'm so sorry, guys.
Oh, no big deal.
I'm sitting in a hotel and it's a little bit hot. I don't want this fan going because it's loud. Okay, guys. So let me explain the way that debt works here and why it's fraudulent as it is. So again, so it's a debt-based system. So our founders and forefathers who framed our Constitution, they were simple but wise men. They weren't developing complex principles or elaborate institutions which only men of rich or educated or noble statuses could understand. You see, what they were trying to do is they were simply trying to create a legal accounting system that adequately and fairly reconciled the debt that was owed to society. If you choose to violate the law, you incur a debt to which you are charged and then called to account so you can pay the debt. Now, these are all very simple accounting terms. Now, the way the debt normally works is if I want to purchase something from a store, a bill will first be generated, which I sign and accept. Then my account gets charged and I incur a debt to which I then have to pay. This is a very simple method for transactions which anyone can understand. However, if the store charges a person's account without billing them first, that's called fraud. You must always bill before a charge is generated. Now, how this affects all these cases is that an indictment is called a bill. So absent an indictment, people are being charged fraudulently because they're not being billed first, right? So if you're arrested and charged with a crime without having a bill of indictment in place, that charge is fraudulent. They got Capone on less than that, right? Or on more than that. You guys, you cannot be billed or charged without being billed first. That's a simple accounting flaw, right? And so I understand the forensic accounting system. I understand the accounting flaw that exists. The flaw exists the moment that you're charged without being billed first. Very simple accounting flaw. Now, there's a second way that you can look at this from the fraudulent nature, and that is that according to the Constitution, the only branch of government that can create a tax against the people is the legislative branch. No other branch of government can create a tax against the people, right? Look it up, guys, right? Only the legislative branch can create tax against people. In the courtroom, there are three branches of government that's represented. The judge represents the judicial branch. The prosecutor represents the executive branch. And the legislative branch is represented by the jury. That's the legislative branch in the courtroom. So when the debt is not created by the legislative branch, it becomes a tax created by a branch of government that does not have the authority to create it. The prosecutor may not create a tax against the people, nor may the judge, and as a result, absent the jury, the tax is fraudulent. It is unconstitutional because it originates from a branch of government that has no authority whatsoever to be able to create that tax, right? So if the jury did not create the debt through the bill of indictment, the true bill, because that's what you get a true bill. There is no bill that's valid because that tax becomes fraudulent, created by a branch of government that has no authority to be able to create it, right? So therein lies the situation.
You familiar with the IRS form 1098F?
Is that the one that asks for the? No, I'm going to say no. I'll just go there. We'll say no. No, go ahead and explain. Because
I'm going to pop up on the screen. All right, here you go. Instructions for a 1098F. Fines, penalties, and others amount. Basically, specific instructions. Okay. Who must file? The appropriate official of a government or governmental entity, a non-governmental entity treated as a government entity, must file a Form 1098-F, fines, penalties, and other amounts. The Form 1098-F reports the amount required to be paid pursuant to a suit, court order, or agreement with respect to any violation of a law or the investigation or inquiry into the potential violation of a law if the aggregate amount involved in all suits, orders, or agreements equals or exceeds an amount determined by the secretary threshold amount. The amount required to be paid includes costs to provide services or to provide property. A separate Form 1098-F must be filed with respect to each payer that is a party to the suit, order, or agreement.
Yeah.
And let's see if I have a copy of one. Yep, there it is. And let me show you what one looks like. Real simple. Could be a check.
Yeah. Yeah. So where I'm at right now, I'm working with someone who just won a massive suit from a jury, and it was a jury trial at United States District Court, and she was awarded let's see,
5 figures, 6 figures, 7 figures.
11 figures.
A lot of zeros.
11 figures. 11 by a jury, and no one knows about this yet. But I'm here to bring this information out. We're scheduled a press conference because the state is now not acknowledging the award from the jury, but it's signed by the jury in United States District Court, stamped by the clerk, and it comes with an awful lot of zeros behind it. 11 zeros.
Well, hit me up, and if I'll broadcast your press conference live as well. I know you want to get this out there.
Yeah, this right here, this much money is enough that we're going to get their attention. We're going to get their attention on this because one, this is enough money that if this person wants to finance the work that I'm doing, we're done. There's nothing that's going to stop this information, because information can move with money, right? I mean, money can buy press, and money can buy advertisement space. And there's enough money right now that this is over. It is absolutely over. And so the court's going to need to make a decision here, because we have a jury that awarded this, and this is enough money that we can get 12 million children back home to their families out of these institutions. This is enough money that it might actually become more expensive for them to continue doing business unlawfully than it will be for them to actually decide to act lawfully, which was what we were trying to do. Right. We've been trying to do this for a long time, reach a point where we're looking at this and saying, how do we make it more expensive for them to continue to act unlawfully than it is for them to step back and start acting lawfully? And we might have just found the angle, because with just a small portion of the money that she's awarded, if she gets behind this with me, just a very, very small portion would be enough that we could get a whole lot more of these done. And with just a couple more, we're
a whole lot more of these. What are you describing there?
These wins. Because we dialed in on one particular win right here, and we made it happen through a common law court, through the United States District Court, but a common law jury that was impaneled by that court. And for that reason, with just a little bit of money, we could make this happen a couple more times, and we would bankrupt these states in no time. I mean, this one right here is 100% going to bankrupt the state that we're in. The state's going to have a hard time coming up with the money that was just awarded by this jury on settlement. It was just awarded, and that's why the state is refusing to acknowledge it, because they're saying, where are we going to come up with this money? That we don't have that much money, right? So now we've got a state that has a judgment against it, signed and sealed by the clerk of court, and the things that's already in place that we're already working. she's going to have her kids back because the United States Marshals are directed to go and do it. They by law have to go and follow the order of this jury and go pick up her children and return her children to her. And not only that, but now we also have a massive amount of money that is also being awarded to this family for the crimes being committed by the state when they took away these children without lawful authority to do it. So, this is enough money that if we do a couple more of these states are done. They are bankrupt. And so, I think we've got some amazing things that could be happening if I can successfully make this press conference, go as I hope next week. And if it does, then I think we're at a point where we're finally going to start this tour, because the United States Supreme Court, they're a business. The United States of America's business. Everybody, we all know it's a business. But as a business, when it starts losing money, then that business, we get their attention, right? And we got their attention right here, at least a small portion of the business, one state. But if I can replicate, or if we can replicate this to another state, we're going to have a whole lot more attention, because these states are going to start falling pretty quick, because this is one case out of hundreds of thousands of cases that could have been chosen within one single state. And the payout that was assigned by the jury is such a massive number that this one case is enough to bankrupt this state. 100%.
City of Houston just about 2 weeks ago, you can look this up, got a default judgment that was finalized. $100 million that they do not have.
Mm-hmm.
They're bankrupt. They're, I don't know how they're still functioning when they're $100 million in debt. They're already in debt.
Yeah. Well, yes, there is a matter of them paying it. We're not doing this for the money, right?
Right. Yeah, obviously.
And I'm certainly not here where I'm at right now fighting alongside these because of the money. They're not doing it for the money. We're doing this because this is what God has empowered us to do. We're doing this because these children need help. We're doing this because this government needs to understand its place and its role within our society. And if they don't, then we're going to make sure that they have no existence whatsoever. Because if their lifeblood is money, we're going to take that away, and we're going to take it away really quick, because that's our money, not your money, government. Right. So the current, the judgment that went into place that was signed by the clerk of court, signed by the jury himself in United States District Court, was $10 billion for one single case that is now won with the jury. And the state is not wanting to acknowledge this. They're trying to keep it quiet, but it's enough that this one case is sufficient that we can bring the entire state down with one single case. And we've got 100,000 that are waiting exactly like it, that are ready to stand up if this state doesn't concede really, really quick. So, what I would say to Mr. Stitt and Mr. Drummond is I've warned you numerous times. I warned you just a couple months ago when I sat on KBOB radio, and I told you that you have all the evidence in front of you. You know what you're supposed to do. You better get these kids back home. And if you don't, then we're coming after you. And I'm going to make sure that the whole country knows the criminal that you guys are, right? I've sat down with you, Mr. Stitt. I've sat down with you, Mr. Drummond. You've been warned. I've informed you numerous times, and you've chosen to ignore this. But you know what? You ain't ignoring it anymore, because you now owe this family $10 billion decided by a jury, right? A jury of her peers, and they decided she's entitled to it. So I would just suggest that you go ahead and step up and do the right thing, or you know what? You guys are done. You're cooked, right? And you're traitors.
The state's not appealing?
State has nothing to appeal. It's a judgment signed by a jury. It's already been through the trial.
Okay.
They took it through. The trial's over. The jury has signed it in the United States District Court. It's stamped and sealed. Today, we delivered to the United States District Court. We delivered a writ of execution for the marshals to deliver her children to her, because that's what the jury said. Give her children back now, and she's entitled to this money. Signed, sealed, and done. So that's what we're looking at. One case. Stitt and Drummond. If you guys don't step up, I'm telling you right now, I got 100,000 more that's coming right behind it. You guys can do the right thing, and or you know what, you're just going to implode on yourself and you guys are going to be done. You're going to be known for the criminals, piece of shit that you actually are. And I've warned you numerous times, Stitt and Drummond. I've warned you. I've told you guys that, you know, that you guys can come back. You can return to established rule of law. You can work with me. We can work together to figure out how we're going to fix these problems consistent with what the law demands. But if you just sit and you ignore it, this is what you're going to be facing right now, because the people are tired of this. We're not putting up with it anymore. You're not going to steal their children any longer.
So what can my audience do to get involved, to assist you, help you get this thing moving, help you in other jurisdictions?
Yeah. So I would love it if next week we could get a good audience, right? I would love it if we could get some people to come out, but I'm not going to be able to give advance notice on the date or on the time, because I need to be very careful about my presence. But I'm going to say next week, Tuesday or Wednesday, at the state capitol in Oklahoma. Come out, be watching, be listening, and if you guys live in Oklahoma, come out and let's show a force here, and let's have ourselves a real press conference to celebrate this win that we finally got with a sizable amount of award, because I can guarantee you that the person that got this win, she's taking this money, she's putting it back in to fight every single cent of it's going back in, and we're going to get those 12 million children back home. We are on a crusade now, and we've dialed in at least one effective win, and now we're going to start replicating this as much as we can. We are going to bring the system down if the system isn't willing to do it themselves, right? So there's that. But I will say that right now, as of this moment, there is no money. So I still continue to operate on donation only. I do the work that I do for free because my clients don't have money. People in prison, they don't have money. I don't get paid for the work that I do. I'm going to tell you guys, I'm this is my last night in the hotel right now, guys. I might be sleeping in the car, but God has always been behind me. He's always been backing me. I've always had the things I need, but I need to make sure that you guys are aware of what I need. And I'm going to say that if you guys believe in the things I'm doing, if you're inspired by the words that I say, the work that I'm doing, then one of the best things that I could get from you, besides your prayers, is donations, because that's the only way that I operate. I operate on donation and donation only. I will not accept a paycheck. You guys can't buy my mind. My voice is not for sale. My body's not for sale. I fight for everyone, and we're going to continue to do this until this is over. There's only two ways for me to get out of this. That is that either that army retreats or God calls me home. And I think that you can all see that God's got me protected, so we don't got to worry about number two. So let's worry about the first one and making that army retreat, because we got them on their heels right now on a lot of different ways, not just the family court, not just the indictment, but we have them on their heels because we got a DOJ memo that was just issued 2 weeks ago where the DOJ admits that everything I'm saying is right. All these judges are unconstitutional. Therefore, everything they're producing is unconstitutional. Where do you guys think that the momentum and the pressure to make them do that came from? It came from getting out here and serving these 48 attorney generals, these 48 state Supreme Courts with actual notices, letting them know that they're acting criminally and they don't know how to respond to this. So they're just simply throwing stuff out there. But I'm going to tell you guys right now, I'm going to tell you that what that DOJ memo was, it's not what you thought it was. Please listen to what I'm about to say, because that DOJ memo, it's not what you think it is, right? Last year, June 28th, we had the Chevron ruling that came out. Chevron was all about executive branch. You cannot do whatever you want to do. So that's what it was about, right? The heart of the issue, executive branch, you cannot do whatever you want to do. That was June 28th. Then on July 2nd, 1 week later, they came out, same court came out in the Trump immunity case and said, executive officer, you can do whatever you want to do. So you have two rulings that are directly contrary to one another, and yet you guys aren't asking why that is. You guys need to think about this stuff. Why is it that 1 week they say executive branch, you cannot do whatever you want, but the very next week they say executive officer, you can do whatever you want? I knew from that ruling that there was a quid pro quo that came into place. Something was wrong with those two rulings, and I didn't know what it was until 2 weeks ago when that DOJ memo came out. That DOJ memo, what they're trying to do is they are trying to get all of you to believe that these judges are not judges, that they all work for the executive branch. They're all hearings officers, ALJs. They work for the executive branch. And you know why? Because Mr. Trump was granted immunity. Therefore, he can extend immunity onto his agents. If you buy into what the narrative that they're creating, then if they are part of the executive branch, then they can be granted immunity. And if they're granted immunity, then everything that they've done is valid. And therefore, they've gotten out of this problem and not getting through it. I want all of you to know, do not buy into this narrative. Do not accept what they're telling you. And the reason why is this, is that if I walk up to you out in town with a water gun and I point at you and I say, give me your money or I'm going to shoot you, right? If you believe that that water gun is a real gun and I portray it as a real gun, it's a real gun. And I'm going to prison for robbery, right? Because it's up to you and your interpretation and how I portrayed it to you, whether or not it's real. Now, same thing here. These ALJs, right? They might very well work for the executive branch. They may very well be hearing officers. But when you walked in that courtroom, did you believe that they were anything other than a judge? No, they were a judge. They portrayed themselves as a judge. You believe that they were a judge. You believe that they had the authority to do things they did. Therefore, they're a judge. Do not let them control the narrative. Do not let them create the diversion that they're trying to create so that you accept that they're part of the executive branch. Because if you do, then they can be granted immunity. And that's the direction that they're going with this, right? This is a diversion. It's a diversion because they're not trying to get out of this. And the reason why I know that, remember, what I used to do is I used to create diversions for government. That's what I did. I'm one of the best that they had. I'm sure they're sorry to have lost me. But the way we know that they're lying about this is because if the executive branch believes that these judges are not judges and believes that they're unconstitutional, then why is it business as normal today in that courthouse? Why are the prosecutors still continuing to prosecute today? Why is it you walk in the United States District Court today and they're still holding cases and courts? Why is it business as normal between the executive and the judicial branch if all those judges are unconstitutional? If they're unconstitutional, why are you doing anything with them? Because that's actually misprision treason. You see, their actions and their words are not aligning with one another. And until they do, they're not telling you the truth. And I want all of you to understand the truth is that actions speak louder than words. Don't believe the words, believe their actions. And their actions show it's business as normal. Don't buy into the delusion, guys. Don't accept what they're saying. It didn't work with Chevron. You all know, you read Chevron, you're like, oh my God, here's the answer. Was it the answer? No, because Chevron was simply an illusion. All it was words, but they had no intentions of actually making it happen. They just were saying things to appease you, to give you the delusion so that you didn't see what they were doing with their other hand, right?
No enforcement.
Right. They're still creating policy today. They still write policy. They still got to enforce this policy. There's nothing that's been changed. Chevron means nothing. All it was a bunch of words to tell you guys we're fixing the problems, to appease you so you all can walk around and say, oh, the problem's solved, because you guys aren't noticing their actions. You're reading their words, but you're failing to understand or recognize their actions. Words and actions must align or else you're a liar. Guys, they're liars. They're still liars today. There's nothing that's changing today, because if it were, their actions would be producing a change, and it's not. So don't accept the things that they're saying. Just understand that this is what they're trying to do. It's all it is, a diversion. They want to get you looking over here to get you to accept that these are all executive officers working for the executive branch because they granted immunity to the executive officer last year, right? And when they did, the executive officer can grant immunity onto his agents if you accept that narrative. Don't accept it. Those are judicial officers. Those were judges. When you walked in that courtroom, you didn't believe anything short of that judge was a judge, and he was there with the authority he had. Now, if he didn't have the authority to do it, remember the water gun scenario, right?
Right.
Water gun, right? So I have Cash App, Chime, Venmo, PayPal. They're all exact same. So we shall be free. If you guys want to get behind this, I would welcome the donations. We would welcome that. The other thing that we need more than anything else, I'm about 120,000 affidavits short of the 500,000. The 500,000 is a number that I told the U.S. attorneys the last time I was in in Las Vegas. I told them that this is the number that I'm going to reach. Once I reach 500,000, I'm going to be returning to Washington, D.C. with these, walking to the Supreme Court, saying to them, what do you want to do with these 500,000 crimes that are being committed by your agents under your watch? Either you let me argue this and you address this, or you guys are responsible for it. You're directing all these agents to commit these crimes because you're aware of it and you're not going to do anything about it. And that means you may as well be the very person pulling the trigger. So if you guys have been charged with or convicted of a crime by the justice system, doesn't matter what state you're in, if you've been charged with or convicted of a crime, then you can get an affidavit from my website. It's www.tanawah.com. That's TANAWAH.com. Top left there says download affidavit. Guys, you're going to have to put in your email address. I'm not trying to harvest information from you, right? That's not for deceptive reasons. The only reason why I do that is because I want to have a listserv of everybody so that I can quickly get an email back out to you. So I'm sorry if you guys don't like putting in an email, but I need that email. So what you can do there is you can download that email or download that affidavit and fill it out. Now, remember, there's only 22 pieces of information that goes into it. Do not add anything else but that. What I'm doing here is I'm creating a standard procedural situation, right? That's the same for everybody, because that means that if there's 2.9 million people that had the same procedural situation happen to them, then I can litigate one case. And when I win one case, all cases win through what's called vicarious relief. So I'm creating a class action suit here, right? Where everybody is going to have the exact same scenario. And again, when you read the paperwork, these affidavits, like, I don't want to know your prosecutor's name. I don't need to know your prosecutor's name, because that prosecutor was portraying himself as a prosecuting attorney, right? So there's a lot of people that don't know who their prosecutor was. I don't want to know that. I don't need to know your case number, because that's secondary. All that I need to know is the basic facts that someone on this month and this year did, someone portraying themselves as a prosecuting attorney did charge you, victim of crimes, of an infamous crime, by information, not by indictment, as required by the Constitution. That creates the deprivation of rights under color of law. That only requires 4 pieces of information: month, year, name, your name, and that's it. And the county that the prosecutor was in. That's all the information we need. Now, the second part is, on such and such month of such and such year, this person portraying themselves as a judicial officer did conspire by and between a person portraying themselves as a prosecuting attorney and a person portraying themselves as a law enforcement officer to deprive you, victim of rights secured by the Constitution, when they held you to answer for an infamous crime without an indictment by a grand jury. You were held to answer without indictment. That creates the conspiracy, and that's all the information we need. Doesn't matter what state you're in. That is all the information that's necessary. And then you go down to the bottom, you sign it, put in your date, the date, and that's it. It's the exact same procedural situation for everybody, no matter what state they're in, no matter what crime it was. None of it matters. Now, a couple key things is that this is basically a citizen's arrest. It's a felony committed in your presence. So if you witness the person being arrested and they're now in prison, you can sign for it because you witnessed it. It was in your presence, right? But if you were not, then we have to either, one, have someone that has a power of attorney. Now, this is a civil power of attorney, right? The ability to initiate civil action, because it's a civil action up until the point when indictments are handed down against these crimes by the agents. So if you have a power of attorney, you could also sign these affidavits as well. And if not, then we have to get the actual victim. We're going to have to get that from prison, from jail. And there's a number of prisons that actually have these affidavits in. Alabama prison system does. Virginia prison system does. Pennsylvania does. There's a number of states that have these affidavits already within the prison system. They're spreading them around. So, if you can get one into your loved one, do it. I don't care if they're handwritten. Just make sure that they use the exact same words. Do not add anything. Do not detract anything from it. Just make sure that they use the exact same scenario. And I don't care if it's handwritten. But then what happens then? We have 10 post office boxes across the country right now. You're going to send them to one of the 10 consolidation points, and those are received. And like I've got a box over here of about 35,000 affidavits that we've gotten. I picked that up yesterday from the Missouri consolidation point. So we're going around. You guys are sending them in. I'm going around and picking them up. We're taking them into our custody. I'm taking that evidence and I'm hanging on to it. So if you have been charged with or convicted of a crime by a justice system, get us an affidavit. And once I reach that 500,000, once I get another 120,000 roughly more, we're going to have enough. I'll be returning to Washington, D.C. But what we're planning right now is the final trip around this country. It is the victory lap. And it's going to be 32 press conferences at 32 state capitals over the course of 40 days, ending in Washington, D.C., where there won't be a single news station in the country that won't be there. Meet me, greet me, and watch me as I walk the Supreme Court to deliver oral arguments on behalf of all of you for the deprivation of rights and freedoms that have been robbed from you by this government. And so we're on our way there. And we'll be starting out of Oklahoma when that tour does begin. And right now, it's just a matter of collecting the funding that's necessary to finish it. And hopefully next week when we have this press conference will be sufficient to springboard us into starting this tour and ending in 40 days back in Washington, D.C.
Okay, I got 7 minutes before I have to cut off the video. I apologize about that, but I want to be able to make those shorts.
Yeah.
Because you have a lot of things I still want to ask you about and talk about, definitely. So we'll have you back on. Do you have a schedule of the state capitals that you're going to be at? Is that available on your website? Are you going to post that?
So we've got the route. We're just waiting on the start date. So,
okay.
So the very first stop is going to be Jefferson City, Missouri, and then we're going to be doing the Northern Loop. So it'll be Jefferson City, Missouri, Indianapolis, Indiana, Springfield, Illinois, Columbus, Ohio, Lansing, Michigan, Madison, Wisconsin, St. Paul, Minnesota, Des Moines, Iowa, Lincoln, Nebraska, Topeka, Kansas. That's the first loop. Then we do Western Loop starting with Denver, ending with Santa Fe. And then we start the Southern Loop starting with Austin, ending with Tallahassee. And then we start the Mid-Atlantic, Georgia, Atlanta, ending with Annapolis, Maryland. And then we start the Northern Loop, which is Dover, ending in New York, and then returning back from New York from there into Washington, D.C., and that picks up to 40 days. I've done this actually 3 separate times over the summer with the 40 days. It's a pretty intense trip, 22,000 miles each time. This time's going to be a little bit more intense, but we actually have a recording artist that wrote a song specifically for this. She's going to be traveling with us. She's going to be opening up each one of these stops. I've got at least 5 people that are already ready to go with the tour bus. Once we get the tour bus, they're ready to go. We got tablets. We're going to be collecting information from all of you, printing out so we can get affidavits collected on site from these. We have a group, the torture center up in Chicago, that's interested in doing a rally. We've got another group, the Prison News Network down in Dallas, that's looking at doing a rally for me. We've got Mike Tyson's manager.
On your Dallas one, if you need a facility, let me know. I have some friends up there in Plano. Fabulous place.
So I look forward to coming back on, Floyd, but all of that will be available on the website once I know dates, but I can't know dates until a couple things fall into place and I have the funding. So, we're looking at about $22,000 that we're short right now on having the funding necessary to make this happen. Once we have that funding, God says, get going, because we're going to reach that 120,000 number. I have no doubt whatsoever about that.
We'll do what we can here for you.
Yeah.
Thank you very much for being here. I will definitely talk to you over the weekend. Is that fine?
Absolutely. Yeah. Anytime.
Okay. I'll give you a call. I'll have you back on. Thank you for being on the show. Any last words for the audience?
Oh, guys, so a patriot is defined as one who loves and defends his country, guys. And so if you say that you love something, but then in the same breath, you say you love this country, but in the same breath, you can't say that you love your fellow countrymen. I'm going to say that you might want to work on your patriotism a little bit, because this country is nothing more than an aggregate of the people. We need to learn how to treat our people better than we're doing today. And so if we're going to love this country, let's start with the love of our fellow man, brothers and sisters. Let's have some passion and kindness for them. I've learned to love this country because of the time I spent amongst all these people that most people don't want anything to do with, and I actually have found them to be pretty amazing people. So thank you guys so much. God bless. Thank you.
Thank you very much. They have some amazing stories. I'll have you back on next week, hopefully with the press conference. Thank you for being here. All right, kids, there you go. I hate to cut him off, but I got to make this 2-hour demarcation line so I can do the shorts. Apologize for the abrupt ending here, but thank you for everybody being here. Always, I appreciate each and every one of you. Be sure to like, subscribe, share, hit that notification bell, leave a comment below. If any questions, you can call me on my cell phone. Go to my website, fearlessfloydshow.com. It's at the bottom of it. If you need anything from the new store, want to pre-order Ann's book, fearlessfloydshow.com. You can reach me, the Fearless Floyd Show at yahoo.com. Thank you, everybody. Y'all have a great, safe, and happy weekend. If you're in Houston, I'll be